All right, good afternoon, everyone. This is the Family and Juvenile Law Subcommittee of the Judiciary Committee. And we are going to get started here with 3 bills that we have to review. And today is Monday, February the 26th, and we're going to start off with HB 690. And Delegate Davis, if you could come online for us.
Yes, I'm here.
Okay, great. And can you just tell us really briefly what this bill does?
You all will recall that the Charles County delegation has had difficulty for this 11-member board. I'm in my car and I'm sorry. An 11-member guardianship board, they had a difficulty finding a psychiatrist. So we have asked that of the 11 members that we are be allowed to replace the psychiatrist with a psychiatrist aide or another medical professional that I don't remember because I'm in my car. I'm so sorry. But as we as we stated in the hearing, that it is supported unanimously by the entire Charles County Commissioner Board and the delegation. Thank you.
Okay. And I think it was to authorize the appointment of a physician's assistant or a nurse practitioner in the field of psychiatry.
Thank you so much. I appreciate that. Yes, that is
no problem. Are there any questions by the committee on this bill? Let me see. This bill also, if I'm understanding, had a delegation letter to support it. There was only one, let me see, unfavorable, and that's the Department of Human Services. Let me see. And that was because they mentioned there was another bill, SB 270, that addressed the same concern. However, this is a county bill, and I know in most instances when the county delegation agrees or supports a bill, we usually support those kinds of bills. But I don't see anything else on the record regarding this bill. Does anybody have any questions? If so, could you please raise your hand? Use your hand feature for that. Okay. Any concerns about this bill? And moving forward? Yes, Delegate Valentine, please go ahead.
Thank you, Madam Chair. The only thing, I think you already confirmed, this only applies to Charles County, correct?
That is correct.
That was my only question. Thank you.
Yes, that is my understanding. Delegate Davis, that correct? Only
yes,
applies to Charles County.
Yes, it only applies to Charles County.
Okay. All right. I don't see any other questions. Delegate Davis, thank you. Oh, one more. Delegate Boucher, go ahead.
Well, it's not a question. I'm motion to move the question. You call to vote on it.
Thank you. Do I have a second on the bill?
Second.
Great. Delegate Taylor, thank you. And so why don't we go ahead and take a vote to move this bill? And what I'm going to do is ask everyone to either raise their hand feature or say yay to moving this bill forward. Hold on one second. Hold on before okay, we got him. We got him. Okay, perfect. All right. All right. And I am also a yay on the bill.
Aye.
Okay. All right. So I see 1, 2, 3, Delegate Pastor, Bartlett, Kaufman, Tomlinson, myself. Let me see. Did I see Boucher? Yep. That looks pretty unanimous to me, unless I'm missing a count. Nope. Any objections to the bill? And if so, would you say nay, please? Okay, looks like the bill successfully passed through the subcommittee. Thank you very much, Delegate Davis.
Thank you so much. Charles County thanks you.
Bye-bye. All right. We're going to move on to our next bill, which is HB 542. And we're going to need to bring into the room Delegate Vogel if he's available and here. And also the Department of Human Services, Rachel Sledge. So let's give them a moment to join us. And also Secretary Lopez is here, it looks like. All right. Great. Oh, Delegate Pastor and Delegate Tomlinson, you can take down your hand features.
Oh,
No
so
problem.
sorry.
No problem. No problem. All right, let's see. All right. Hello, okay, hello
Hi,
there.
Delegate Crutchfield.
Hey, hello, and hello, Secretary Lopez.
Good afternoon.
All right, is there anybody else joining you guys on this? Okay. All right, great. All right, so this bill, I don't see Delegate Vogel anywhere, so I'm gonna just briefly talk about this bill. This bill was to establish and maintain a supply of new luggage to be used to transport personal belongings for children in foster care. And there seemed to be some concern from the Department of Human Services. So I wanted to make sure we brought them into this discussion. And so let me ask the committee, do you have any questions for Secretary Lopez or Ms. Sledge, who also represents the Department of Human Services regarding this bill?
I do, Madam
Okay.
Chair.
All right, Delegate Kaufman, go ahead.
I understand Secretary Lopez, that you are opposed to this because you say that foster children are already given luggage, and so this is an unnecessary bill. But we had people testify to the exact opposite. And so what I wanted to know is, if this is already being done, why would people testify? Like, where's the disconnect? Why would people testify that it's not being done? Because you didn't attend the hearing, but I had several people testify at the hearing that it's not being done. So if you could talk about where the disconnect is coming from, that'd be great.
Happy to. So first of all, for the record, we didn't oppose the bill. We actually submitted a letter of information because we wanted to strengthen the bill itself. And that was part of why we put on the record in writing some clarifications. So let me just start there. Number two, I was unfortunately in back-to-back budget hearings, which is why I couldn't show up to your committee, or else I would have. So let me walk through dispelling some of the myths that I've unfortunately uncovered in this role at DHS. So let me just be very direct about what we found. When it was brought to my attention that the issue of black garbage bags, it's really clear to me that any kind of use of garbage bags or disposable trash bags is absolutely ethically unacceptable to transport any material or any belongings of any child under any circumstance. That's crystal clear. However, when I dug into this, when it was brought to my attention, I discovered by asking a few simple questions as a secretary, what we had in writing in terms of policy and accountability. Turns out there's inconsistency across the state. And so one of the things I talk to all of our local jurisdictions about is that I don't want to have 25 different ways of doing things in Maryland, particularly things that should be consistent. There should be one way, the Maryland way. And so I asked for whether or not there was a policy in writing that allowed for clarification on the transportation of any young people's belongings. And in fact, there was not. So I actually had drafted and have in front of me the first ever policy that is about to, we're finalizing literally as we speak, that will go live to every single one of the jurisdictions with accountability measures around trauma responsive and appropriate transport of children's belongings on what is acceptable and what is not acceptable. And that was a response to my simple question of, well, what is Maryland's policy then? Number one. Number two, the disconnect is that unfortunately between a combination of, let me back up for 1 second. I then asked for photos of every single 24 jurisdiction storage where they had luggage, suitcases, duffel bags, backpacks, all of which are brand new. And every single jurisdiction confirmed for me visually that we actually had state purchased material to transport kids' belongings. So to your question, Delegate Kaufman, there is in fact a disconnect. And part of the disconnect is a culture of practice in the state of Maryland that is allowed to happen for some time. And that has been a combination of our private providers, sometimes attorneys, sometimes other advocacy organizations, and sometimes potentially even DHS staff. So my concern was that there wasn't consistency in terms of our expectations as a department for the ethical and thoughtful treatment of young people who should never have their belongings transported in plastic bags. So that's bottom line, the disconnect, why I wasn't able to attend your original committee hearing, and why we've drafted a policy that will be released statewide. And the final point around the issue we provided in the first letter of information and then submitted to the Senate in testimony, both in written form and in oral form, something that I want to make sure I bring up to all of you who I know who share my concern about this, which is the issue of record keeping. And so the current draft policy that I just referenced, there's a section, and I will read it as currently drafted. All LDSS, which is the local departments of social service, must maintain a record of all instances in which a disposable bag or container not meeting the definition of luggage was used, the extraordinary or emergency circumstances related to such use, and an explanation for the failure to use appropriate luggage. So my expectation moving forward on behalf of the department for the state of Maryland is that it's never done. And if on some occasion, for some rare instance, an emergency it is, I want to know why. I want to know the date, time, and specifically what happened so it never happens again. So that's, hopefully, Delegate Kaufman, an answer to the various questions that you've posed, and happy to answer any.
Thank you, Mr. Secretary. Very helpful.
Sure.
Yes, thank you. Are there any other questions by the subcommittee? So I have a few, please, Secretary Lopez. When is the effective date of your policy that you are finalizing?
So it'll be final the day we release it. It'll go in effect immediately. It's currently dated February 22nd, only be with the effective date of March 5th, only because it's still, we literally drafted it a week ago when this was first brought to my attention. And so we have a few more changes. I'm looking at the line items right now, and we think we'll actually get it out in the next couple of days, including, just for example, images on what is acceptable and not acceptable in terms of transporting materials. We have to be that explicit so that we can say to everyone partnering with the department that we intend to create this cultural shift across Maryland, raise the bar of excellence on expectations, and hold ourselves and our partners accountable. So we'll go into effect within a few days of when we release it. And happy to provide any of you copies with that.
Yes, if you could do that, please, that would be very helpful.
Happy to.
Just
Happy to.
send it to me, and I'll make sure that all the subcommittee members get that.
Wonderful.
The other question I guess I have is that you mentioned, are there currently any of the different Department of Human Services now actually providing, is that what I heard? That there are some that are currently providing luggage type of transporting for children's belongings, and that there are obviously others that are not. So what are we talking about? How many are actually doing this in each county? I mean, I'm assuming it's broken down by county.
Right.
So which counties are actually providing this and which are not?
Right.
And so therefore, this policy needs to be put in place to make sure we cover everybody.
Right. So I want the policy in place to cover everybody and to raise the bar of excellence and have accountability. When I asked the question, what do we currently have in writing? And the response I got was, we don't. That was unacceptable to me. So I then asked the follow-up question, who has luggage today? Right? Like the day I asked the question. So I forget what day it was. It was sometime last week. And I wanted visual proof. I wanted to see what do we actually have. So to your question, Delegate Crutchfield, every single one of the 24 jurisdictions has existing brand new luggage, brand new duffel bags, and brand new backpacks. The question then becomes, why in any instance were they not used? And that's what the policy is attempting to address, is that there should be, moving forward, no reason why they are not used when in fact we have state purchased and state stored and state accounted for existing brand new luggage. We also wanted to strengthen, Delegate Crutchfield, that this isn't just about entry into foster care, it's in any placement move. So for example, the picture that was used at your testimony, that particular individual young person, that was not on entry into foster care. It was between two placement moves and not moved by Department of Human Services staff member at that time. That's still no good excuse. This should never, ever happen. But we wanted to make sure that on behalf of this department and this administration, it's any time a child is moved, including between foster parents, between kin, and other kinds of placements. Why? Even if they have another piece of new luggage, we wouldn't mind that the young person is already using a decent piece of luggage or a duffel bag or backpack to move their stuff so that we never have to use a garbage bag. So that's to your question of who doesn't. According to what I was told, they all have storage, and I have images of where they're stored to prove that, in fact, we do have them, because I wanted to make sure that was clear. And number two, the policy is to address it so that there's never a loophole around the use, inappropriate use of garbage bags.
Okay, and so I'm going to go ahead to a couple of questions from subcommittee members. Delegate Taylor, if you'll go ahead with your question.
Thank you. And thank you, Secretary Lopez, for being here. Appreciate you guys actually, creating this policy. I think it's wonderful. Comfort cases played a huge role in the hearing. And you did mention duffel bags. So I was just making sure that the picture that you have created as a part of your policy includes the duffel bags. I think you did mention duffel bags a couple of times. But then secondarily, what role would comfort cases play in the ongoing effort to make sure kids have these duffel bags or any kind of luggage, or do you see them playing a role?
So I want to be clear about that, Delegate Taylor. I'm glad you asked the question. One of the things that we have to be really careful of as a department is not to show any kind of favoritism around a potential procurement around anything. So Comfort Cases is an actual business who has, from what I understand, a current contract with the state of Georgia to provide comfort care cases. So one of the things I made sure we did as a team was to better understand, what do we do now? So for example, if 13-year-old Kim Taylor were moving placement to placement, and she happens to be in, say, Queen Anne's County, what would Queen Anne's provide both on behalf of the state and any volunteers who wanted to donate items? So you actually would get, if you were right now in the care, you would get actually some version of one of these. It's hard to show you online, one of these sort of appropriate items, which includes a duffel bag, a backpack, or a luggage, depending on what it was that you were needing to transport. Similarly, we purposely showed what things we would reject as appropriate. So for example, grocery bags that are plastic in nature, or paper handled bags, which, for many things are perfectly appropriate, but not for 13-year-old Kim Taylor, right? And so each county has partnerships and a variety of nonprofit organizations, churches, volunteers who contribute a variety of both donated materials that are brand new, as well as those that are purchased by the state of Maryland for each of the 24 jurisdictions. So there is customization or curation so that young people get the kinds of things that they should get. Are we there as of today with 100% consistency? Not exactly, which is why we want to make sure the policy conveys raising the bar of excellence, consistency across the state, one policy, and holding ourselves accountable for having the opportunity to make sure young people receive both the luggage and the care they need.
Thank you. Madam Chair, can I ask a follow-up?
You may.
Okay. And wow, just flew out of my head. Give me a second.
You can come back anytime.
It's okay, Delegate Taylor.
Right.
It happens to me all the time, Delegate Taylor.
Right.
It happens.
Yeah. Oh. Will you still accept donations? Was my question.
Absolutely.
Okay.
Absolutely.
Okay.
Although I will say, if you can all help us spread the word, we would prefer brand new items. Why? Because young people who are going through a traumatic experience, they deserve the best. And I do not want them to have even gently used items, because there are lots of other places that take and accept gently used items. This is not one of those instances. I would want brand new material, and then we would work carefully. In fact, some of our LDSSs, in responding to our request, were saying that they sometimes have a hard time managing what's donated to them, so that we can raise that bar of excellence as well.
Thank you. Delegate Simpson, you have a question?
Yeah. Oh, I appreciate that. I do kind of recall when there was kind of the push to make sure to have that luggage for kids, because when I was doing child welfare, I would just at especially at the intake, since you don't know when you're gonna take a child, I do like the idea of having something that's foldable and portable that you don't have to go out to your car, to get. Because as you know, you don't always know when that's going to happen. But I think it's fantastic that you all have that. So I really do appreciate it.
Sure.
Isn't that so?
No, you're exactly right, Delegate Simpson, and it ties to Delegate Kaufman's question, which is why then sometimes when you have the best of intentions in a policy, is there a disconnect? And so one of the things I was stressing is, as humans in this very complicated work, sometimes, people forget and they shouldn't. And so how might we make sure that that staff who are assigned, whether it's on a weekday or a weekend or an evening, that they have these bags also in state issued cars? Why? That way they're always prepared. We never want to have a situation where there's a disconnect. So that makes sure that they are mobile, and if they need to be able to go get them, they can get them from the office as well.
Yeah, and I also remember, I think there was a time that you all were doing like comfort kits, if I recall. It wasn't during my time, but I understood that there was kind of like a new kit that you were providing as well to kids that were newly in foster care, like the toothbrushes and that kind of stuff. Is that?
From what I understand of all 24 jurisdictions, there's some version of that happens across the state, but they also are varied, and there isn't like a single kit, which is what I was trying to reference regarding the question on comfort cases, that there isn't necessarily one vendor. There's actually multiple ways that the local departments of social services are getting those services. And from what I understand of the homework that we did, all of them are funded by primarily state of Maryland general fund dollars. And then backed up by the contributions and donations that Delegate Taylor was asking about.
I really appreciate that you're standardizing it. I think that's fantastic, and that you're doing it in a very conscious way for all of the services that you provide, because it could happen at various different stages.
Absolutely.
So
and I'll repeat to all of you what I said to the Senate. If you ever hear that it happens, I want to know. Because the point of this is that we don't want it to ever happen, but if it does, it's not to bring blame or shame. We have to fix it. It's to the disconnect, so that kids don't get the message that they are garbage, right? And they already in a complicated world oftentimes get that message unnecessarily. We don't want that to happen. So it's not about snitching. It's about trying to course correct a policy that's going to take some clarification to make sure everyone is following it statewide. And there's one way statewide, not 24.
Got it. Thank you so much.
Certainly.
Delegate Kaufman, did you have another question?
I did not, Madam
Okay.
Chair.
Okay.
I have a point I'd like to make, but I don't have a question.
Okay, let me come back to you, okay?
Okay.
All right. I have one more or Delegate Simpson, do you have anything else you'd like to? Okay. All right. Secretary Lopez, really quickly, I know this is funded through multiple ways, but do you have a budget line item for this particularly, so that if there are counties or jurisdictions that cannot necessarily do it, they can at least come back to you? So tell me, I just want to make sure the funding's in place, just to shore up everything. If you could just talk to that, please.
Absolutely. As of right now, based on the research we did in response to the bill, there is not a single jurisdiction who does not have a way to pay for brand new luggage, duffel bags, equipment. That was what we were told directly from all of our directors of the local departments of social service. That was the first point. Number two, to your question, people use a variety of resources to pay for them. So there isn't a singular budget line item that says brand new luggage, because different LDSSs will rely on different sources of state funding to compensate, to make sure that they're able to purchase them. We asked the question if anyone has any difficulties, because they could always reach out to the Office of the Secretary, which we would work with them and their Office of Finance and our Office of Finance, and no one said they had any problems accessing money. So I believe at the end of the day, Delegate Crutchfield, again, very much to the theme of how do we make sure we have accountability so that we have clarity on money, clarity on what to purchase, and clarity on the use of any new luggage to ensure we do not have garbage bags used.
All right, thank you very much. I
Certainly.
appreciate that very much. All right, any other questions?
Can
Okay.
I say something now?
Yes, I'm getting to you right now. All right, I just want to make sure we've covered everybody's questions. I don't see any more hands up regarding that. And go ahead, Delegate Kaufman, with your comment.
My recommendation, Madam Chair, is that I really applaud Secretary Lopez, and of course it's your subcommittee, so it's up to you. But my recommendation is that I would recommend or suggest that we hold this for a week, because I want to see if the Secretary Lopez said that the list would be finalized on the 5th of March and that he was still tweaking it. And I also would like to try and get Delegate Vogel's perspective, but I personally wouldn't feel comfortable giving this an unfavorable report until the list was finalized. And he said it will be done by March 5th. So my suggestion is we hold this for a week.
Okay, thank you very much, Delegate Kaufman. And in fact, I think I am right along with you in that we need to hold it and give Secretary Lopez an opportunity to get his policy in place and for us to get a copy and actually review the policy and confirm that it's actually what we would like it to be. And I think you also had on that policy, is there an attachment, Secretary Lopez, that actually describes the luggage?
It's literally describes and shows images.
Okay,
I'm looking at the draft right now. It's 3 pages long, and it's pretty. We wanted to keep it simple.
Okay.
As you know, when you're trying to get thousands of people to make sure they're being consistent, you want to keep it really simple and easily accessible. So we're trying to say, here's what you could use, here's what you can't, and lay out some basics around it. So happy to get that to you within the next 24 to 36 hours, actually, because I'm the one now that needs to read the final version.
Okay.
So I can get it to you. Happy to do that. Rachel will make sure she gets it to you, and we'd love any feedback.
Okay, perfect. So that's what we will do. We will hold the bill during that
Fantastic.
time to take a look at everything. Thank you very much,
Thank you
Secretary
all so much
Lopez,
for your
being
partnership.
here today. We really do appreciate it.
Likewise. Have a wonderful afternoon.
You too. All right. I believe our last bill for today is up, and that is HB 406. And we're going to let our witnesses in the room, and then we will ask Delegate Simpson to go ahead and get started once they're in the room. Okay. You too. All right. Delegate Simpson, if you will. Okay, thank you for muting yourselves. Thank you. And who is on the iPhone? Who is, if you can just state your name.
Hi, it's Brett Engler, Delegate Crutchfield.
Okay, perfect.
Sorry, my computer video does not work.
Okay, got it. Thank you so much. All right, Delegate Simpson, let's get started. Just summarize the bill for us, please.
All right, what a wonderful panel. They look great. Thank you all for being here. So in summary, this is, remember that piece that has not been done. This part of the law has not changed since 1973. And when we passed that marital defense was not a defense, then we obviously needed to fix this to make sure that if there is communication, that we're not forcing it upon anyone, but if they so choose to be able to want to share that information, if they are a victim of a crime by their spouse. Anyone else want to chime in to share a little bit about the bill, make it clear?
Sure, Delegate Simpson. So this is Brett Engler. I'm the chief of the domestic violence unit here in Frederick County. And I think this bill is just really important, like the delegate said, to make sure that we're not, as married women or married men, we don't have less rights than someone who's not married in terms of choosing to hold our abuser, our rapist, our assaulter accountable for their crimes should they be our husband. So there are two, for the non-lawyers, there are two types of privileges. There's a privilege, a testimonial privilege, and there's a communication privilege. So as a spouse, if my husband were to have hit me, I can choose whether or not to testify against him one time in the state of Maryland. If it were to happen again, I would have to testify. You can invoke a marital privilege to not testify one time. That doesn't mean they're necessarily acquitted, but that's a whole other thing. You don't have to testify one time. But if you do want to testify, so that is a right that I hold as the victim. I can choose to, I can choose not to one time. The husband and the wife both hold the communications privilege. So let's say I am brutally assaulted, raped by my husband, and he's going to say it's consensual, and we have case law to this point. He says it's consensual, I say it's rape, and it's a he said, she said, and the evidence is what it is. You go to trial, the state thinks they have enough evidence, and part of that piece of evidence is, let's say, a text message. I'm sorry, but you are out of line. F you, something like this, a love letter of apology, or something that's just an admission of what they did to you. The victim alone does not hold that privilege. Both spouses do. Even if they are divorced, if that communication happened within the marriage, the offender can keep that piece of communication, so not her testimony, but that apology, that confidential marital communication, out of court. So the victim ends up, practically speaking, getting up there, sharing her trauma, saying that is my rapist. And the defense attorney says, well, we don't know if that he's your rapist. He's saying it's consensual. And she wants so badly to share this letter of apology or this text string of him saying, gosh, I've had offenders say all types of things after their offense to their victims. And if that is relevant to proving his or her guilt, the state could be forbidden by the offender from using that in trial, and the victim could not testify to it. So it's just a grave injustice that almost all states, save for like 3 or 4, and I had a 50-state survey that I emailed to the delegate, have an abrogation of the marital communications privilege when it involves a crime against the spouse. So we're just way behind on that, and I really hope that the committee gives a favorable report. I'm here for certainly any questions. Thank you.
Thank you very much.
I recall a case where after the husband would beat the wife, and this was when I was doing child protective services, would send her a dozen roses with a card that would say, I'm sorry, I love you, So there's all sorts of examples that are out there.
Okay. So Debbie Feinstein from the State's Attorney's Office in Montgomery County, would you like to?
Hi, good afternoon, delegates. I just want to confirm, in addition to what Brett said, we discussed this bill at the Maryland State's Attorney Association Special Victims Committee, which is made up of representatives from the different jurisdictions around the state. And this is an issue that is impacting all of our jurisdictions. It's not unique to Montgomery County or Frederick. We are seeing this across the state in every jurisdiction. And, for the reasons that Brett Engler articulated, I absolutely support this bill and changing this law, which is antiquated. Thank you.
Thank you very much. Does the subcommittee have any questions for any of our guests? Okay, Delegate Bartlett.
Thank you, Madam Chair, and thank you all for your test for giving us some clarification. Delegate Simpson, I am eagerly awaiting to vote in favor of this bill, but I just have a quick question. I don't know, it could be for Brett Engler or either Debbie Feinstein. I'm not sure, but before we said that we even agreed to having rape in a marriage, we wouldn't even have been able to use that testimony because there was no crime. Do you agree, Ms. Feinstein? I see you nodding your head.
Well, I mean, I think what happened with the rape statute is the perpetrator could invoke a complete defense to rape if they're married and it's no force articulated. So it would have applied to like a mental incapacitation or cognitive difference or physical helplessness is where we saw those come up most often. But that was different because that was a complete defense to the crime. So we couldn't even go forward on those. But in this instance, it, say under the prior iteration of the law where the spousal defense did not apply to rape in the second degree where force was articulated, because that was removed from the books like many years ago, thankfully. But in that instance, if the perpetrator had said something to the victim afterwards or during or any part of the commission of this crime or its aftermath, we currently cannot use that in that trial. So that's in a second-degree rape with force. That's in any of the other iterations that we see of sexual offenses, or really any crime. This isn't unique to domestic violence or sexual assault. It occurs across the board, and we certainly see other crimes that occur between spouses, in under many different circumstances. So this is just sort of not allowing the perpetrator to take advantage of essentially of this privilege to escape their wrongdoing.
Right, right. Okay, thank you very much.
Yes, thank you. Delegate Valentine, I believe you have a question.
Yes, thank you, Madam Chair. Actually, I have a few. The first is a comment. I want to thank ASA Engler for explaining the first component, which was the spousal privilege as well as the communication, and that there's two separate entities. I had that question to begin with, but that question's been resolved. My second question, and if I'm reading the bill properly, is the may testify component. So this is in no way going to be where one spouse is compelled to testify. No more of the one in the life of a marriage. That does not apply to this particular bill, correct?
Yes, that's correct. And when we were drafting it, there was an amendment to make that absolutely clear, because it's still a privilege that we're just putting the privilege in the hands of both rather than one. So if one wants to share this communication, this taunting, this letter of apology, the other one should not be able to forbid them to do it for the sanctity of the marriage, a marriage that has been irrevocably altered by a forcible rape or an assault, and the victim wants to leave. They want to participate in the criminal justice process. They want to participate in the civil justice process, such as getting a protective order. And sometimes these communications are absolutely critical evidence, not to mention sometimes, there are control calls and rapes and things like that, where the victim should be able to use evidence that supports their claim.
Okay.
And my last question, if I can, Madam Chair,
Yes, you may.
is to the point of the Maryland State Bar Association letter with other crimes. And has that been resolved where you have this communication for an incident, but I don't want it to be kind of going outwards to where that will now include, say, a spouse says, well, my husband has stolen property, or something that is not related to that victim. Has that been addressed so that that's no longer a concern of the Bar Association?
So, in fact, we have Michelle Smith here from the Bar Association. I'll let her address that.
Thank you, Madam Chair.
Thank you, Madam Chair. Hello, delegates. Michelle Smith on behalf of the Maryland State Bar Association. I'm not aware of any amendments. I have to say that it's not a hill I am willing to die on with regard to this bill, because I think it's an excellent bill and very needed. I think some of you may know that I was a prosecutor for 20 years before I became a family law attorney, and I have to tell you, I'm excited about this bill. So I'll defer to others as to whether amendments have been made or discussed or even needed. Honestly, I think that perhaps they're not absolutely necessary, because I think the judge is there as a referee to put up a roadblock to any irrelevant evidence, especially if there's going to be a jury who's hearing such things. Sometimes the cat gets out of the bag before it can be stopped. And I certainly have had circumstances like this where one spouse starts telling other bad acts of the spouse, and it happens so fast. It's hard to put everything on rewind. But I do have a question while we're at it, while I'm deferring to Debbie and Brett on that issue. Have you all, and I don't want to be a fly in the ointment. Honestly, I want this bill to pass from the standpoint of the Maryland State Bar Association Family Law Section. But just with my old prosecutor hat on, I have a question. The bill talks about spouses not testifying against other spouses, but have you considered that broadening that a bit? Because really this is a marital communication and people get divorced in my world. People get divorced after such bad incidents, and then they wouldn't be a spouse. So I certainly would want to include those people. And I'm not suggesting you should do a massive rewrite of the bill or anything like that, but has that been considered? And did you purposely use the word spouse there?
So I'm going to let Delegate Simpson chime in, and then we'll go to the other prosecutors on that question. Go ahead, Delegate Simpson. I think you.
Yeah, I was just for the first part, we had discussed it. I think we actually discussed it the day of the hearing that we decided not to make any adjustments to it because yes, the judge would be the one that would determine what's relevant, not relevant and all that. And that's kind of implied in court rules.
And are you referring to, what are you referring to exactly, Delegate?
To the initial question about
amendments or?
Right, about at this time, there are no amendments to it because it was determined it was not necessary, which was already kind of covered. And regarding the other, Brett, do you want to touch on that?
Sure. I didn't think that would necessarily be necessary just based on the historical case law in terms of marital communications, in that the communications privilege only applies to things that occur within the marriage. So after they're divorced, if there's communications there, that wouldn't be something that would be barred.
No, I think you're missing my point. So
Sure.
if the husband rapes the wife and then they subsequently divorce, and it takes her a while to testify, it's a felony, so it could take a while, and she testifies not as she's no longer a spouse. Would this law permit her communication? Do you think it's clear enough? Because it says very clearly a spouse.
Well, when the communications was done, they would have been the spouses. Go ahead. Was that Debbie or?
No, that was me, Delegate Crutchfield. So I guess the question that you're really asking is, which it sounds like they're no longer married, right? And so now that they're no longer married, this is considered a different kind of communication, right? And so therefore it probably, and that's the question, can it be let in? Because she obviously is no longer the spouse. So we're just talking about a rape and a witness and testimony regarding whatever that was.
I think I'm not being clear enough.
Okay.
The husband rapes the spouse. The very next day, while they're still married, he sends her an apology letter or apologizes in text or whatever it is. She divorces him. The rape case occurs when they're no longer married, and she wants to be able to testify regarding the communication that occurred while they're married. But she's no longer a spouse.
Right. So is she barred or not barred from that communication?
I think she's barred.
Under the current iteration of the law, you mean she's barred?
Yeah, is she
Under the current iteration of the law, she is barred because the communication was made during the course of their marriage. Now, if they get divorced and then he says something about it, once they're divorced, that's fair game.
Sure.
But no, you're right. I think that even if they get divorced afterwards, the spousal privilege remains for any communications that occurred during the course of the marriage. Was that your question?
No.
Oh no.
No, I'm following. So Michelle's saying, Michelle's saying that if there's a prosecution, first, this is unusual, but it could happen that the rape, it's a delayed report or something. So they're divorced by the time we initiate a prosecution. So to fix what Michelle's suggesting, then I would suggest a prosecution of the spouse or former spouse.
Right.
And then that might fix it.
Yes. I don't want to suggest amendments because this is your guys' bill, but I just thought about that would help. I think it would make it better.
I thought the issue with the way it's read is between spouses occurring during their marriage. And I thought that took care of the whole thing as to why we didn't get into the former and all that, because the language specifically says spouses occurring during their marriage.
Yes,
right.
that's not
but
the
Delegate Simpson, there are times, right, when the spouse is not able to really elaborate at that time. And
Right,
so
they're not
as-
safe yet.
Right,
And
they're not,
usually
and so
go
they
to
get the
court.
divorce, and then what happens next? Now she feels safe, now she feels like she can talk about what happened. So
Right.
I think that's what that is referring to.
So it's the first clause and the last clause. A spouse or a former spouse who is the alleged victim is competent to disclose a confidential communication between spouses occurring during their marriage in a criminal action in which one spouse or former spouse is charged with a crime against the other spouse, whichever former spouse, you know, I don't know where you want to throw it in at the end there. And I'm not trying to suggest amendments to your bill, but I think it would make it better.
Oh, it already says former spouse? That's not.
No, it
bad.
does not.
It does
Oh, it
not.
doesn't. Okay.
I agree with what Michelle is saying. Thank you for that clarification, and sorry it took a little while for
No
me
problem.
to get there. But yeah, Delegate Crutchfield, I would agree, and I looked to Brett for the final word on it. This was her initiative, but I think it does add a necessary clarification because if they're not currently married, yeah.
Well, and if you think, and this is more of a question for Michelle, but my understanding is the family law has changed in so much as we're getting faster divorces in theory. So
Correct.
hopefully that's so maybe you would be divorced before a major rape case goes to trial.
Absolutely. Delegate Simpson, can you hold your, okay. Delegate Bartlett, go ahead.
Well, I think I saw Delegate Simpson nodding her head because it took me a while to matter of fact, I want to make sure that Michelle Smith looks at all my bills in the future, because I read this thing over and over again, and I was like, it says right there, they're you know, during the marriage, but it's that last spouse that's the problem, where it says that a crime against the other spouse, and so that person, they're no longer married, and I get it now. So anyway, I saw Delegate Simpson nodding her head, so I'm not going to beat the horse anymore. But I think it makes sense with the with those changes.
Okay. All right, Delegate Simpson, do you have any comments?
I'm not opposed if the, I mean, I know the subcommittee has the ability to make that change and that amendment to it to make it stronger. And, you know, let's face it, you know, the whole point of what we're doing is to work together so we make it stronger for the people that are on the front lines. And so I think the 3 people on the front lines, if that's what they want, let's give it to them.
All right. Okay, are there any other questions to our guest? All right, I don't see any. What we'll do is we will hold this bill, take a look at it, and review it again for possible amendments to it. And we'll proceed that way with this. Thank you so much to everyone. That concludes really all of our work today. And do I have a motion to adjourn?
So move.
Perfect. Thank you so much. And again, have a great weekend. And that ends our subcommittee meeting. And just be on the lookout